Thanks for stopping by Minnesota Black Robe Regiment. As always, make sure you're checking out the subscription bar down there or the little banner right there on the bottom corner of the screen, because now you can subscribe from right in the video while I'm jabbering on. There's also a bell icon down there so you can make sure you're getting actual notifications about when my content comes out. And as most of you know, I do almost everything as a premiere to give you time to prepare yourselves. And that's mostly psychological preparing. Not gonna lie, I understand you have to psych yourself up into watching my stuff, but I enjoy it. So there you go. I'm angry. Um, why am I angry? Why is TC always seems angry? Like the a video I just put out here several days ago um, was not angry. It was a positive report about Kay from the Steele County Times and the wonderful journalistic work that she did. And I wanted to praise her for that. I wanted to laud her and applaud her for demonstrating what journalistic integrity and journalistic ethics look like. And I sent that video to the editor of the Steele County Times, who also is the editor of several other papers in that region. And that felt weird, but it felt good. But that's not the case today. TC is angry. TC's very angry. And we're going to start off with this little tidbit because it's personal. This is an issue of personal anger. I have a inside source in the Owatonna area, and this individual will not be named. I am protecting their anonymity because this needs to be out there. Mark Sebring, allegedly, I'm not saying this is a statement of fact, but the source is incredibly reliable. And it would not be, should we say, normative for this individual to be spreading disinformation. And the person that gave me the information just would have to have been conned or suckered into having this information to share with me for nothing other than to cause division and derision and schism. I'm rhyming now, so I'm going to stop. But I don't see that being the case because the information that was shared with somebody who I let's say I trust. And the problem is that the Owatonna School Board, in particular, Mark Sebring, the chair of the Owatonna School Board, and I would also, Jeff Elstead, the superintendent of the Owatonna School District, is not on the board, but we all know that Elstead pulls the strings, that he tells the board what to do, and they do it, so that they work as a rubber stamping entity for Jeff Elstead. So what I'm about to tell you is part and parcel of the mentality of what's happening there. So keep in mind, I did a video a couple of days ago or a while ago that demonstrated that Sebring completely misunderstands his authority and asserts rights for the council. And I indicated in there, and I have witnesses who heard this. Elstead stated that he has the authority to have anyone who's disruptive removed from school board meeting room. Well, and that's true. Absolutely true. Now, being the school board chair, he gets to be the arbiter and the final subjective decision maker when it comes to what is disruptive. Just like we talked about in another video, he gets to determine what is considered profane. He gets to determine what is considered defamatory. He gets to determine what is considered a personal attack or private information that shouldn't be disclosed. He gets to make all those decisions. He makes all those decisions on the fly. There's no uh, precedence. There's no policy and procedure that regards those things. It's just strictly something he gets to decide on the fly, especially when it comes to public comments. And even people asking questions during the regular meeting. Now, there again, there's a place for a certain level of decorum, but there's also a place for public accountability. And I have audio of Jeff Elstead, the superintendent, with Mark Sebring in the room telling several citizens, their employers, their masters, telling them that they're about accountability, public accountability. It was reported to me today with much detail, and not total and 100% clarity, but with much detail, that Mark Sebring has approached a member of the community and said that TC guy is hurting the cause of the people he's supporting, and we are going to bar him from entering during in the next school board meeting. And if we can't bar him from entering during the next school board meeting, we are going to not allow him any type of voice. And I'm paraphrasing what's being said to me. So Sebring's plan is to keep me from entering if he can. Barring that, ironically, they're going to not allow me to speak. And so here's what will happen. Here's how this will play out. He'll say something asinine. I will have to respond, and then he'll have me removed for not demonstrating decorum or for being disruptive. Now remember, he's already threatened this. And now he's plotting this and sharing this with somebody in the public. And this has gotten back to me. The only way that Mark Sebring is going to be able to have me removed is to have law enforcement there. The only way that he's going to be able to have law enforcement remove me is to claim I'm disruptive, which would then be disturbing the peace. So he could have me charged with that, or he could say, well, let's have him removed and then issue him a trespass order. Now, could they do that? If you put yourself in a position to do the bidding of Mark Sebring to silence me, you are going to have to ask yourselves, are we going to rely on the Nuremberg defense? And who do you work for? I don't care what the name of the chief of police of Owatonna, excuse me, did I say Albert Lee? But if Mark Sebring, the chair of the Owatonna School Board, has shared that he would like to bar me from entering and bar me from speaking, if he can't bar me from entering, there's only going to be one of two ways to get me out of that building. One, forbid me entrance. Based on what? What are you going to have me trespass for so that I cannot enter? Who are you going to have serve that trespass? If I am allowed to enter and then I speak and then you have me removed for being disruptive, are you going to have me charged for disturbing the peace? Are you going to, number two, have me trespassed? If I agree to leave, are you going to then have me trespass so I cannot come back? Then who is going to enforce it? And there again, I don't care what the name of the chief of police of the Owatonna Police Department is. I really don't. At this point, I do not care. You need to understand that you don't work for the Owatonna School Board. You may have an agreement to provide school resource officers for them, which is absolutely, necessary, because it's pretty clear that there's some problems in the Owatonna School District because, they've had a couple of riots. And Superintendent Jeff Elstead had no problem talking about that and talking about how it was all because of people's racist bigotry. That's what it was. He made it very clear that the riots that have happened is because of bigotry and racism in the school. So you definitely need school resource officers. But this is, once again, we'll get to you, Mark. This is a fair question going in to the Owatonna Chief of Police and to the Owatonna Chief of Police officers. Are you willing to risk civil litigation to bar a member of the citizenry from entering a building when no crime and no actual disturbances happened? And if you tell them it won't, I laud you if you tell him that's not going to happen, that you're not going to comply with that. Good on you. But if you tell him, well, if you order us to have him, if you ask us to have him removed for being disruptive, we'll do that. I'm still going to ask you if you're familiar with the Nuremberg defense. The First Amendment, and there again, the Owatonna School Board is not required to offer a public forum, but the First Amendment states that we have a right to a redress of grievances. And if public servants, elected like the school board, appointed like the chief of police, or the principal or the superintendent Elstead, or hired like school staff or officers in the Owatonna Police Department, you work to serve us. You serve us. And if you are going to determine to take your orders from the chair of the Owatonna School Board and either bar entrance to people that they don't want there, or as an alternative, be ready to step in the minute he decides that somebody's being disruptive after he says something asinine and stupid, which Sebring says a lot of asinine and stupid things. He's underprepared for the position he has, and he is not equipped to stand toe to toe with me in a debate on these issues. And yes, Mark Sebring, that's a challenge. If you would like to have a debate on these things, please, just me and you on a stage in Owatonna, in a place of your choice, maybe your brewery, friendly territory for you. Open it up to the public. Have people come in and you and I can debate your position and your power and what authority you think you have. I will gladly eviscerate you in a worldview debate, in a philosophical debate, Mr. Sebring. You do not stand a chance. But if your answer, because I'm coming over there and I'm supporting people who are holding you accountable, and your answer is to try and remove me or bar me entrance, there is no room in your wallet or your bank account for the kind of civil litigation damage that you are going to receive. And I will bring that same damage on a civil level to anybody who follows any of your orders. When I'm done, the only school district that will be left will be a shell, because everyone's going to have to go to a charter school, home educate, or send their kids off to Medford. You are on warning. Then there again, not a call to violence, not a call to any kind of aggression, but you are not prepared for this, Mr. Sebring. If what I was told is true, you are not ready for the political, philosophical, socio-cultural storm that is going to come your way. Now for part 2. From an inside source. So, Minnesota open meeting law states that the law exists to require transparency and accountability, and I'm paraphrasing. It's in place. It's in Minnesota State Statute, Chapter 13D. Here's what it says. And it is now codified in Minnesota Statutes, Chapter 13D. The Minnesota Supreme Court has articulated three purposes purposes of the open meeting law to prohibit actions being taken at a secret meeting where it is impossible for the interested public, doesn't say interested public who has an address in the school district, by the way, interested public to become fully informed about a public board's decisions or to detect improper influences, to assure the public's right to be informed, to afford the public an opportunity to present its views to the public body. These purposes are deeply rooted in the fundamental proposition that a well-informed populace is essential to the vitality of our democratic form of government. Courts interpret the laws liberally and in favor of openness. Entities covered by the law. The law applies to state and local multi-member governmental bodies, including committees and subcommittees and nonprofits created by political subdivisions. A separate law applies to the legislature. Situation where the law applies. A meeting is a meeting for purposes of the law when a quorum of more of the government body is gathered, in person or by electronic means. Whether or not action is taken or contemplated, the open meeting law does not address whether the governmental body must keep or publish meeting minutes, hold a meeting for a particular purpose, or allow members of the public to address the body. As I have stated ad nauseum over and over and over again in multiple videos, contrary to what the Owatonna People's Press stated, I have not spread any misinformation, and I have actually clarified with the United Patriots for Accountability and other concerned Owatonna groups that they're not obligated to give you a public forum. For any particular governmental body, there may be other laws or charter provisions that address these topics. What constitutes an open meeting? A meeting is open when proper notice was given in advance of the meeting. The public may attend and observe, and relevant materials are available to the public. They're doing a very poor job of that, by the way, in most places, actually. Exceptions to the law. As I have educated other people about this before, when it comes to Owatonna and Albert Lea and other places, a meeting may be closed on a limited attorney-client privilege and for the purpose of labor negotiations, employee evaluations, and discussions of security issues and property transactions. The law does not apply to governmental body exercising quasi-judicial functions involving disciplinary proceedings. Now, I may add that the open meeting law states, and I shouldn't say states, but it is stated that a employee who's facing discipline may request that their disciplinary hearing be held in public in front of the public for the purpose of transparency. Boy, that had been fun to do in Olmsted County with Sheriff Kevin Torgerson, Chief Deputy Brian Howard, Olmsted County Sheriff's Office in Olmsted County, but we'll dismantle them in a different video. Violations of the law. While action taken in a meeting held in violation of the law are still valid, the law provides for penalties and potentially removal from office. Where to get advice? A governmental entity can seek advice from its attorney, the Minnesota Attorney General, or the Commissioner of Administration. An individual may seek advice from a private attorney or the Commissioner of Administration. Group meetings covered by the open meeting law. The open meeting law applies to a state agency, board, a government meeting of any school district, unorganized territory, county, city, town, or other public body, a committee, subcommittee, board, department, yada, 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 governing body, or a committee of statewide or public or local pension plans. Public body is not defined, but the Minnesota Supreme Court has stated that, in common understanding, public body is possibly the broadest expression for the category of governmental entities that perform functions for the public benefit. In determining whether the open meeting law applies to a particular entity, one should look at all of the entity's characteristics. So here's an example that they give from 1998. Minnesota Supreme Court ruled that two people from a city council who went to an arbitration/private mediation meeting did not violate open meeting law. Now, here's where we're going to get. I'm going somewhere with this, and so I realize this video is going a little longer, but it's very important that you please listen carefully, as I say in my intro music. Gatherings of less than a quorum of a public body are not subject to the law. A meeting, is held when the group is capable of exercising decision-making powers. cut and dried, right? The Minnesota Supreme Court has held that open meeting law applies only to a quorum. In other words, if you have a board of 7, 4 or more make up a quorum. The Minnesota Supreme Court has held that open meeting law applies only to a quorum or more of members of the governing body or a committee, subcommittee, board, department, or commission of the governing body. Serial meetings in groups of less than a quorum held in order to avoid open meeting law requirements may also be found to be in violation depending on the facts of the case. A public body subject to the law should be cautious about using email to communicate with other members of the body. Although the statute does not specifically address the use of email, it is likely that the court would analyze use of email in the same way it has telephone, conversations, and letters. That is, private communications about official business, through telephone conversations or letters by a quorum of a public body subject to the law would violate that law. Serial communication through telephone conversations or letters by less than a quorum with the intent to avoid a public hearing or to come to an agreement on an issue, and this is going to be imperative for us to understand. I'm going to read this entire paragraph for you one more time. In serial communications through telephone conversations or letters by less than a quorum with the intent to avoid a public hearing or to come to an agreement on an issue relating to official business would also violate the law. In a 1993 case, the Minnesota Court of Appeals held that the open meeting law was not violated when 2 of 5 city council members attended a private mediation session related to city business. The court determined that the 2 council members did not constitute a committee or a subcommittee of the council because the group was not capable of exercising decision making. Now, the law does not cover chance or social gatherings. Cut and dried, right? The open meeting law does not apply to a chance or social gatherings of members of a public body. Oh, Mr. Sebring, you're not going to like this. However, a quorum of a public body may not, as a group, discuss or receive information on official business in any setting under the guise of a private social gathering. Let's read that again. However, one more time, please put your ears on, people of Owatonna, because you have some corruption happening. However, a quorum of a public body may not, as a group, discuss or receive information on official business in any setting under the guise of a private social gathering. Now, remember, we read up here that not meeting as a quorum to avoid open meeting law could be a violation. And down here, the law does not cover chance or social gatherings, right? Especially if there's no quorum, but they cannot, even if there is a quorum, they cannot receive information on official business in any setting under the guise of a private social gathering. So let's deal with this. Where am I going? My inside source. Now, you need to understand that what I'm about to share does not constitute a quorum. Okay? I'm not arguing that a quorum was had. But my inside source has indicated to me that Deborah Bandel, who is a director of the Owatonna School Board, met on a previous occasion several months ago in a restaurant for a meal with Jolene Mose, our Jelaine Mose right here, if you can see the mouse moving, who is the treasurer of the school board, and Nikki Geiske, who is also a director. They met in a local restaurant. I know from my source on the inside that Jelaine and Nikki badgered the heck out of Deborah Bandel, talking to her about her views on the business of the school board, talking to her about what she believed about certain things, asking her about certain people in the community as it relates to their activity as members of the community who would often speak and hold the school board accountable. They put pressure on her about topics that the school board would cover and ask her her views on those things and ask her how she would feel about those things and where she might vote on those things. Now, they're again not a quorum, but also not meeting as a quorum in a way to avoid open meeting laws as quorum is stated. At the very least, there's an appearance of impropriety. Now, maybe or maybe not, Ms. Bandel was counseled to not ever meet with anybody in that situation again for the very appearance of avoiding the appearance of impropriety. Now, one would think that that would be enough, but it wasn't. Ms. Bandel was called again to meet with, this time, the chair of the school board, Mark Sebring, and Lori Weisenberger, who is the vice chair of the school board. And they met. And the same thing happened. The same thing happened. And we're still, this has happened since the conversation about critical race theory and critical theory and all those other critical theory in general started to come up. Those same things happened. Mr. Sebring, Lori Weisenberger, met with Deborah Bandel and pushed in on her about her position on things like critical theory, critiqued her speaking at a meeting, and said that she was out of line and that what she was doing was detrimental. And there again, I'm taking this off of, this is information reported to me by an inside source who knows these entities, these parties, these individuals, and knows that this meeting happened. Now, am I saying that open meeting law was definitely violated? Absolutely not. I'm not saying that. But what I am saying is that has at the very least the appearance of impropriety. That 4 members on 2 different occasions, 2 one time and 2 another time, came together and put pressure on Ms. Bandel about her views, about her stance on issues that would be coming before the school board. And question her affiliations and question her about people that she knows and how well she knows them and what she knows about them and what they would do and how she would handle things and how she would vote and what would go on and yada, 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 yada. Not once, but twice. Not once, but twice. And in one of those situations, the latter situation, Chairman Mark Sebring of the Owatonna Public Schools School Board made it very clear that he was disgusted with Ms. Bandel's position for what she said at a community meeting, at a public meeting, and told her she was out of line. Now, is he entitled to do that as a private citizen? Yes. But at the very least, ladies and gentlemen, especially in the Owatonna School District area, and quite frankly, the citizens of the state of Minnesota, the appearance of impropriety should be enough to have this investigated. Period. So if you're seeing this video and you are a member of the Owatonna Public School District community and you are a citizen, you should be asking yourselves, what is the potentiality of what all of what TC's talking about tonight could cost us? Because if they take steps preemptively to remove me or bar entrance of me into their venue, wherever that might be, because we're hoping that they'll change the venue. Because I know for a fact that numerous people have been sending emails to the school board and to the superintendent demanding a change of venue, very politely, very civilly, but have been demanding that. So we're hoping for a change of venue. And please note that if that change of venue is granted, it will not be for any other reason than the fact that the public pressure from the concerned citizen groups like the Patriots, United Patriots for Accountability, and the concerned parents and citizens of Owatonna have been putting enough pressure on the school board that they know that they are going to have to change the venue, or they are going to have to deal with civil disobedience. But if they succeed in barring TC from entering the building, or if they succeed in having me removed because he declares I'm disruptive, they're going to have civil litigation on their hands, because we're going to have the video and the audio to prove that it didn't happen. And if they succeed in barring me, we'll have the video and the audio of them barring me entrance to a public place of a public accommodation for no valid reason. And if they have me trespassed, we'll have video and audio of that. And there will be civil litigation. Not only will there be civil litigation brought against the Owatonna School Board and the Owatonna Public Schools, there will be civil litigation brought against any representative of the city of Owatonna who does not intervene as their constitutional duty would say. And any officer or any representative for the Owatonna Police Department who follows an unlawful order that violates the Constitution. Let's see, because every single person in public service has qualified immunity until such a time as they violate the constitutional and civil rights of private citizens. That means to the Chief of Police of Owatonna, that means to you, Mr. Sebring, to you, Mr. Elstead, and to every other member of the school board, if you have conspired, if you have colluded, if you in any way, shape, or form have spoken ahead of time about how to keep me from entering that building or how to have me removed without any statement of fact of what actually defines what being disruptive is, you have violated my constitutional rights, my constitutionally delineated rights granted to me by the God of nature, which means you can do that to anybody else. The veil of your protection is pierced at that time, and you are no longer protected by qualified immunity, which means that not only is the city, not only is the school district, not only is the school board as an entity on the hook, and the taxpayers have to pay for it, but that means each person who's involved in that situation, in that decision making, if you have colluded and conspired, especially ahead of time, which I have been told you have done, you will personally be on the hook because you are not indemnified, and the school district and the city and the police department do not have to cover you. And I guarantee you, officers, your chief will probably throw you under the bus and say, I never ordered that. I never told them to violate anybody's constitutionally enshrined rights. So you have that to deal with. And then you have to deal with the appearance of impropriety of taking a school board member out and having lunch with them and then talking to them about their positions on issues before the school board in a meeting that was private about school business for the very purpose, and everybody will see through this, of avoiding open meeting laws. Is this the direction you want to go, Owatonna Public School Board? Mark Sebring, is this really the direction you want to go? Do I seem irritated? Mr. Sebring, if this is true, and this has happened, you are already guilty of conspiring to strip me of my constitutionally enshrined rights. And I would love to put you under oath on this. So push it. Bar me from entering. Have them in place to have me removed if I speak up and say, you don't get to tell us we can't, you don't get to tell the speakers what they can and cannot say, as long as it's pertaining to school board business or school district business or school district issues. Go ahead. I have all of the videos showing how you have tried unsuccessfully to dictate what people can and cannot say, because you don't know what you have the power to do and not do, because you've forgotten who you serve. And this is there again, not about violence. This is not about threats of violence. This is not about anybody taking physical action. This is about the First Amendment and dealing with these things through the manners and the methods which are prescribed to us by the Constitution and through the laws and through the courts of the state of Minnesota, and if need be, to SCOTUS. You want to tell people in public you're going to try and find a way to bar a member of the public as citizenry from entering a building because you don't like what they have to say and the fact that they're helping other people hold you accountable? That's collusion to violate somebody's rights. That's collusion to violate the constitutionally enshrined liberties of an individual, whether you like them or not, or whether or not they're from your school district, Mr. Sebring. It doesn't matter. And then to sit there and take a member, the newest member of the school board, and pin them down in two different situations and push them about their views on things that are coming before the school board, even if it doesn't technically violate the law of the laws that are encompassed and shrouded by open meeting laws in the state of Minnesota. It looks slimy, Sebring, and no one's going to be surprised. If you are a member of the Owatonna community and you hear this, you need to be filing ethics complaints. You need to be finding the people that you need to take this to, and you need to be questioning how they could take Deb Bandel, how Jolene and Nikki could take Deb Bandel out and question her about her position and views on things that she should be that she will be voting on in the school board. And you should be questioning how Sebring and Weisenberg, or whatever her name is, could do the same thing and then dress her down for expressing her views as a citizen. There is some sketchy crap going on in Owatonna, and you guys have got to get this under control. And I don't care if you're pro CRT or pro liberty, because if you're pro CRT, you're anti-liberty. If you're pro CRT or you're pro liberty, and you show up to speak, this should bother the bejesus out of you. And if it doesn't, you are part of the problem in this country. But I'm telling you right now, once again, not a threat of taking action in a physical sense or violence, but if I find out, or if I am barred entry from that building, or if I'm told that I can't speak out when something asinine and that is a violation of a person's First Amendment rights takes place, and I speak to defend them, and if I find out that that's used against me and anybody takes action against me, trespasses me, removes me, tells me I can't come in, I'm going to own the Owatonna School District when I am done. And Mark Sebring, you'll be lucky if you have a pot to pee in. And you can lawyer up all you want, but I will find somebody that's got the legal power and the legal guns to take you on. They are chomping at the bit for this kind of stuff right now. So you can consider this my way of offering you an olive branch. Cease and desist. Mark Sebring and the Owatonna School Board, all of these things, or you're going to have a lot of trouble on your hands. This is what tyranny looks like. This is what it looks like when power-hungry, petty little peon tyrants in a school district can't handle being held accountable or decide that it's just not very nice. Owatonna, stand up and speak out for yourselves and let them know that this doesn't end if they remove me. It's time for you guys to take your school district back, and that if that means making your school board incredibly uncomfortable to the point where they can't handle it anymore and they resign, so be it. It wouldn't be the first time that has happened this year in this country. Let it happen again. Set the precedence. Because if you don't, they're going to shut you down, and it will not matter what you do going forward, because they'll just keep doing it, because they prove that they can run roughshod over it. It's time for especially the men who are concerned to stand up and take action civilly, peacefully, but with some civil disobedience. Until next time, Sic Semper Tyrannis.
Please listen carefully. Please listen carefully.